Good day, everybody. Today we are going to talk about some U.S. Supreme Court cases and the impact that they have had on the juvenile justice system and process. That's going to lead us up to a discussion on the court process that we'll talk about next week. Then I'm also going to talk about what is known as the YLSI. It's the Youth Level of Service Inventory. It's a tool that we use in probation to do pre-sentence investigation reports, as well as developing plans to really work with and help youth. So let's go ahead and get started. Basically what I'm going to do is just give us a walkthrough of several different U.S. Supreme Court cases, some of the landmark ones. And ultimately, this all boils down to understanding what a juvenile's legal rights are. And now throughout the quarter, I've talked a lot about balance. And when we look at some of the decisions that the U.S. Supreme Court has had, ultimately what they are really trying to do is balance the rights that we give to juveniles. Ultimately, they're balancing several different amendments. They want to work within the best interest of the child, yet protect the rights of that juvenile. And ultimately, the first few court cases that we are going to talk about were heard in the 1960s and actually the 1970s, and then we'll talk about a couple more current today. But basically, this ball got rolling in the 1960s, and we look at the court system prior to that. The juvenile court was based on the civil court. Now, for those of you that have had criminal law and procedure, you talked a little bit, in Intro to Criminal Justice, we talk about this a little bit as well. We know that there's some major differences between civil court and criminal court. Of course, criminal court, it's the state pressing charges against an individual for a crime. Civil court offers civil remedies. It's person versus person. You can't go to jail or prison for being found liable in civil court. The standard of proof is lower in civil court. And so, things like small claims court is an example of civil court. And so our juvenile justice system was built on that concept. With that, prior to the 1960s, prior to the U.S. Supreme Court getting involved, we saw basically no consistency in the juvenile court process. And so ultimately what was to become the rights of juveniles were being violated prior to these U.S. Supreme Court cases. Now, ultimately, the Supreme Court cases that we're going to be talking about really relate to the Fifth Amendment, the Sixth Amendment, the 14th Amendment, which is equal protection for the most part as it applies to juveniles, and ultimately they all focus on due process and what is fair and treating juveniles fairly. So the first court case is Kent versus the United States, and I don't have these memorized, so I apologize for referring to my notes. On September 2nd in 1961, Morris Kent was arrested for the crime of what they called back then housebreaking. We would call that breaking and entering now, robbery as well as rape. Basically, the fingerprints on the scene matched the fingerprints that he was a suspect in at the age of 14, and so a couple years prior. He was held in detention for a week. He had no arraignment. There was no notice of probable cause given. He then was decided, or the court then decided, that he should be transferred to the adult court or waived to adult court. And that was appealed, and it was ultimately determined that the process that they used did, in fact, violate his 14th Amendment right. And really, the underlying issue of Kent versus the United States was, does due process apply to juveniles? Again, prior to that, they were based more after the civil system. And basically, one of the quotes that really explains this case from the U.S. Supreme Court case is parens patriae. Remember, that's the idea of the best interest of the child, and that the court will act as the parents if the parents are unable to fulfill that role And so the court basically saying is this idea of parens patriae is not an invitation to procedural arbitrariness. So basically this was the court's first move in deciding, yes, juveniles we still want some things different, but juveniles do have the right to due process. They have a right to a hearing, to having counsel, access to records, and then documentation regarding the waiver. Ultimately, what was the most important piece of this U.S. Supreme Court case was in one of the appendix of the case. So the bottom line, the court did state that juveniles have the right to due process. But really what the Supreme Court case zeroed in on was the waiver process. So when we're waiving a juvenile to the adult system, the U.S. Supreme Court addressed this in one of the appendix of the decision, which was very, very unusual for them. And actually, even to this day, it's really unusual for them to address such an important issue in the appendix. So ultimately, in that appendices, the U.S. Supreme Court said when it is being contemplated to transfer a juvenile to the adult system, the court must take into consideration the seriousness of the offense, the level of violence the offense had, the maturity and sophistication in the juvenile, in the planning of the crime. Was it extremely well planned? Those are things that they're going to look at. And then treatment options available. Is there a program in the juvenile system that might be a great fit for this juvenile? If so, then they should stay in the juvenile system, is basically what this case took a look at. All right, probably one of the most popular cases is the In Re Galt case. What's interesting is that it is considered to be the single most important case. However, it built on the Kent case that we just talked about. Now, the name of the case, In Re Galt, you're going to see several cases with this type of titling. The in re means in regard to Galt. Now, ultimately, remember, juveniles cases are confidential, and that's been ever since the beginning of time, and so at the beginning of the organized court system. And so cases were titled In Re Galt, so in reference to Galt. In this case, Mr. Galt's mother is who filed the court paperwork to bring this to the U.S. Supreme Court. So the case is called In Re Galt, or in reference to Galt. On June 8, 1964, Jared Galt, who was age 15 at the time, made an obscene phone call to his neighbor. He had been on probation at the time of this offense. Gerald was taken into custody, was held for court until the next day. His parents weren't notified. He was never notified of what he was being charged with. When he did finally go to court, there was no one sworn in, no transcripts were recorded, there was no complainant present, and no attorney. And so, again, building on the Kent case, so Kent got the ball rolling, but they weren't really articulate in what due process rights they were affording to juveniles. Again, they were more concerned on that transferring cases to the adult system. And so, again, they were presented in pretty quick succession. Does due process apply to juveniles? Basically, the Supreme Court came back and said, yes, due process does apply. And we are now mandating that juveniles have the right to be notified of the charges. They have the right to an attorney. They have the right to or against self-incrimination. However, Miranda, they wasn't specifically notified, and that will make sense here in a little bit. And ultimately, to this day, states get to determine whether or not Miranda warnings need to be given. And then, so those were in some of the Fifth Amendment this particular case then also incorporated the Sixth Amendment, saying that the defendant has the right to confront witnesses as well. All right, moving on to In re Winship. Again, and so we had several cases in a relatively quick period of time. Basically, in 1967, Samuel Winship was accused of entering a locker room and stealing $112 from a woman's purse. Now, remember, this was built after the civil court system, or the juvenile justice system was built after civil court. Civil court has a lower standard of proof. In civil court, to this day, the standard of proof is known as preponderance of the evidence. It's about the same as probable cause, which we sometimes call 52%. It's ultimately more likely than not. And so in civil court, the standard of proof was more likely than not. And so prior to In re Winship, those cases were decided on the preponderance of the evidence. The U.S. Supreme Court in re Winship said we need a higher standard of proof for juvenile justice, where the 14th Amendment provides equal protection and due process. Therefore, the standard of proof in juvenile court needs to be the same that it is for adult court, which of course is beyond a reasonable doubt, which is essentially right about 90% is what we like to call beyond a reasonable doubt. All right, McKeever versus Pennsylvania was decided in 1971. What's interesting here is the U.S. Supreme Court changed their tune. The cases that we've talked about, and there's a couple other that I just, because of time, I don't have, I'm not going to cover, but for the most part, the Supreme Court had been giving juveniles due process rights. So in May 1968, Joseph McKeever, who was 16 at the time, was charged with robbery, larceny, and receiving stolen goods. It was determined that his case should stay in juvenile court. So it was not going to be waived to the adult court. The defense attorney representing Joseph McKeever requested a jury trial, and it was denied. And so they appealed to the U.S. Supreme Court, and basically the constitutional question that this case was asking was, should juveniles have the right to a jury trial? So again, I said that the U.S. Supreme Court changed their tune here. Up until this point, they had been giving the rights to juveniles, the due process rights. Here they said no. Juveniles do not have the right to a jury trial. Remember, it is not a criminal prosecution. It is an adjudication based after the civil system. And also remember, juvenile court is confidential. And so how could we possibly maintain the confidentiality, which we believe is so important, if we bring in members of the public to serve on the jury? So McKeever versus Pennsylvania basically is a Supreme Court case that denied juveniles the right to a jury trial. Breed versus Jones was decided in 1975. Now this case has a little bit different twist on it as well. So Breed was the director of the California Youth Authority. So basically, he was in charge of the youth court system in the state of California. On February 8th, 1971, Gary Jones, so that's where we have Breed. Breed was head of the juvenile court system. Jones was the juvenile, was charged with armed robbery, which would have been a felony if he were an adult. And it stayed in the juvenile system, and he was adjudicated delinquent, which is basically the equivalent of being found guilty. However, at the dispositional hearing, or what we call the sentencing hearing in juvenile court, they weren't able to find an appropriate treatment, something that they thought was a good fit for him. However, there was a treatment for adults in the adult system, and so they made the decision to then transfer him to the adult court system, and he was found guilty in the adult court system and sentenced. They appealed that to the U.S. Supreme Court, and basically the U.S. Supreme Court said that process is a violation of the Fifth Amendment's protection against double jeopardy. If you're going to try them in juvenile court, again, that's one of the criteria that we talked about in Kent. You need to make sure that there is a treatment option available that's appropriate in juvenile court. Once that decision is made to stay in juvenile court, it needs to stay in juvenile court. And so that is why Breed versus Jones is a landmark Supreme Court case. All right, then the last case I want to talk about is the juvenile death penalty. Now, ultimately, when I started teaching, I had to give this, sometimes my lecture for residential classes, we would talk for probably 45 minutes in understanding the court's role or the court's version or take on the death penalty for juveniles. So when we look at this from a historical perspective, we have two cases that the most recent case was built upon. The first was Stanford versus Kentucky, which was decided in 1989. Here we were introduced to the concept of ESD, which stands for Evolving Standard of Decency. Basically what that concept is taking a look at what the public thinks. And we know that what we are okay with is evolving. I mean, you even look at the media. You know, I grew up in the time of Fred Flintstone and, you know, Lucille Ball. And, of course, on television, they couldn't show even a married couple in bed together. That's why Fred and Wilma are in separate beds. You know, that's why, you know, things like the Lucille Ball show, her and Ricky are in separate beds, because it was considered inappropriate to show that. Of course, what we know now, or what we see now, is much, much different, especially daytime TV. Holy cow. So that's basically what an evolving standard of decency is. It's evolving. It's always changing. And basically it takes into consideration public perception. So basically the Supreme Court is taking into consideration in their decisions what the public is okay with. Based on that, in 1989, the U.S. Supreme Court case, the U.S. Supreme Court decided in Stanford versus Kentucky that executing 16 and 17-year-olds was okay. It did not violate the Eighth Amendment. Then another case was decided in 2002. Now, it had nothing to do with juveniles in its decision. Atkins versus Virginia basically said executing the mentally retarded. Now, I know that is not politically correct anymore, but that's the terminology that they use. Now, notice it is not mentally ill. They were specifically referring to developmentally disabled individuals. Atkins versus Virginia said that executing the mentally retarded violated that evolving standard of decency. Because of that, it violated the cruel and unusual punishment clause of the Eighth Amendment. Now, how this applied to juveniles. So generally what they, how they classified mentally retarded was based on an IQ score. So that's what was important, because in the most recent decision of Roper versus Simmons, so as of March 1st, 2005, the U.S. Supreme Court said executing anyone who was under the age of 18 at the time of their crime violates the Eighth Amendment's cruel and unusual punishment clause, as well as the 14th Amendment protection of equal protection. So Roper versus Simmons basically said we can't execute juveniles anymore. It was a 5-4 decision, which is a relatively close decision. It's as close as it can be without being the other way. So done deal. Individual states no longer can do their own thing. Prior to that, we saw very different things. And why I talk about Atkins versus Virginia is in their decision, they referred to the Atkins versus Virginia and that IQ level that was used in that case. And ultimately, research had demonstrated most 16 and 17-year-olds had the IQ that was similar to those that were deemed mentally retarded. Now, we're not saying that 16 and 17-year-olds are mentally retarded, developmentally disabled. However, at that point in their life, their IQs are similar to adults who have developmental disabilities. And so that was the kind of foundation of what that case was about. All right, so that wraps up the Supreme Court cases. I do want to talk about a really important legislative change that was a historical development that played a huge role. So ultimately in 1974, the JJDP Act, so Juvenile Justice and Delinquency Prevention Act, was passed. Now this is the same act. I've talked about the OJJDP, the Office of Juvenile Justice and Delinquency Prevention. That office was created as a result of this act. So that was one of the things that they did. Some of the other things that this act required was deinstitutionalization of status offenders. Prior to 1974, we were locking up kids for status offenses, for truancy, for running away, for smoking, for drinking. So ultimately, as of 1974, the federal legislation stepped in and said it's never appropriate to lock those kids up. If a child is going to be detained or ultimately put in a jail temporarily, of course they can't be in adult jails, which is one of the other things this act said, but if temporarily we do need to house someone in jail while we're waiting to bring them to an appropriate juvenile detention facility, they need to have sight and sound separation from those adults. And then jail and lockup removal, again, they said it's never appropriate for kids to be in jail. And then the last thing that this act did was it already recognized what is known as disproportionate minority confinement, something that we still struggle today with, but this act was the first to formally recognize how minorities are treated differently in our system. Now, we have talked about, and we know that disproportionate minority contact happens at all levels of the criminal justice system. This particular act specifically looked at corrections in dispositions of juveniles and just with juveniles. But basically, the JJDPA Act said we need to do something basically about disproportionate minority contact. One last thing I wanted to talk about is a lot of times I get the question a lot about juveniles having the right to bail. The Supreme Court has never agreed to hear a case about bail for juveniles. And so the judge usually exercises a couple different options. First and foremost, if it's an option, if there's not a public safety issue or a flight risk, the judge is going to release that juvenile to their parents till the next court hearing. If that isn't an option, then the judge is first going to look at non-secure options, foster care, youth programs in the area that are non-secure. And then if they don't believe non-secure is appropriate, then they will look at secure. But right now, juveniles don't get a bail amount because ultimately, that's really just telling the parents that they have bail. And so the court doesn't necessarily believe that that's appropriate, and so won't set bail for juveniles. As far as the future goes, who knows? I personally don't see the court system implementing a bail system because, again, of the fairness and the parent responsibility that might bring. All right, then I do want to talk just a little bit about the YLSI. This is it's actually called the YLSI CMI. And basically this is an assessment tool that we use to determine a juvenile's risk and needs and ultimately take a look at what's going to be appropriate for them. The YLSI is basically based on 4 different principles. First thing it looks at is risk. Now we've talked a lot about risks, and ultimately we do know that there are some errors that that can be made and have a big impact, where ultimately getting the risk level right is really, really important, because if we wrongfully assess someone who is a low-risk offender as high risk, and so we give them intensive services, they're going to become delinquent. It kind of deals in with that whole labeling theory, and so we really need to make sure we are assessing risk appropriately. When we look at needs, it sometimes boils down to risks where ultimately, in order to reduce recidivism, we need to target what those changeable risk factors are. And so risk and needs go hand in hand. And basically some of the things that we are going to look at are called dynamic factors and static factors. Dynamic factors are things that can change. Static factors are things that we have little impact on. So for example, a dynamic factor for a juvenile is going to be substance abuse issues. We can get them to treatment. So that's a dynamic factor, something that can be changed. They might be, you know, have dropped out of school or testing at an 8th grade level. We can get them access to education. Those are things that are dynamic factors. Static factors are sometimes biologically based. The fact that, you know, mom and dad are both in prison or incarcerated. Obviously that has an impact on this child, but there's nothing we can do about it. That particular factor is historical and we can't do anything. Having a prior criminal history, yes, we know that that is going to impact the child, but there's nothing we can do about it. And ultimately, we're really trying to be as strengths-based as possible. The third thing that we look at, or the third principle, is known as responsivity. And ultimately, we need to make sure we are being responsive to the individual. And so a lot of times we will look at what their learning style is. You know, based on some testing and maybe collaborating with school people, how does this child best learn? And being responsive, or responsivity, is matching the intervention that we propose for this juvenile with their learning style. The fourth principle is professional discretion. We know that some kids are going to tell us what they think they want to hear. And so as a professional, in talking about some of these risks and needs and other issues, if I know this kid is feeding me a line, I can override what this assessment tool finds. So let's take a look at what the assessment tool is. Now, ultimately, the YLSI CSI or SEMI is all computerized. So basically, this is as close to I can get as a printout these days of what that LSI looks like. So part one is assessing the risk and needs. And so I'm going to go through this relatively quickly. I will provide a copy of this in our discussion forum. And so the first thing that we are going to assess is their prior offenses. And of course, we're going to verify this. We're going to ask them about it, but we're going to verify it with the court. And depending on their answer, we're going to assess them in here. If they have no criminal history, that's going to automatically be a strength. Then we're going to look at their parenting circumstances, and we're going to ask them these series of questions, and ultimately, based on the total, however many of these they say yes to, we'll fill it in here. If their answer is 0, it's a strength. Education, employment, same thing. Ask them these questions. Based on their answers, we measure the risk. If it's 0, it's a strength. Peer relationships, same thing. Ask them questions about their friends and their friends' delinquent activity. Gets put in here, and again, it's all computerized now. It's nothing, it's a strength. Then one of the other things we ask them about is substance abuse. And again, if depending on how many things they answer, that's how we rate it there. So ultimately, this is the first page of the YLSI. All right, I apologize for that. My computer went a little crazy. Hopefully I didn't lose you. All right, so that's page 1. So continuing on, we talk about their leisure and recreational activities, again, measured based on how many they say yes to or identify with, personality and behavior, ranked, attitudes and orientation. So the YLSI is pretty comprehensive. We're asking them about many, many aspects of their life. And now again, this is all going to be calculated for us, but ultimately what this is right here is where their scores are going to fall. And basically on the printout we get a nice little bar graph of where their risk and needs are based on the different factors that we've assessed for. And then we have an overall total. Part 3 looks at a few additional factors that obviously are going to be important, things like drugs and alcohol abuse, marital conflict in their home, financial problems. Uncooperative parents is a huge piece that we need to take into consideration because, of course, if we want to develop a plan, we need to determine if a family is going to be cooperative, if we want to engage them in a family focused program. We ask them lots of other miscellaneous questions, but are all important in their assessment. Again, it's extremely thorough. All right. Here's that professional discretion, that override. Based on your assessments, is there an override? Most often it's going to be no, because again, we're verifying a lot of these factors. Then part 5 is the contact level. What level? This is, again, based on the risk. In probation, how much contact do we need to have with them? And so, you know, with based on the level that they were decided, we do that. Then ultimately comes the case plan, and this is one of the things that I think is the most rewarding in doing this particular assessment. Where ultimately we break it down by outcomes and then specific goals, and this is really taking baby steps. So let's say, as I said, the student or the juvenile that we're working with hasn't really been to school since the 8th grade, and they're testing at, let's say, maybe a 6th grade level. And so our first outcome is we need to get the student enrolled in school and ultimately either get their GED or a high school diploma. Now, for a 16-year-old kid that already knows they're really, really far behind, that goal is huge. We need to break that down into baby steps. And so that's our outcome. But then we're going to go specific goals. So the first thing we're going to do is we're going to go make an appointment at the Area Learning Center and get you signed up. And then the second goal is we're going to get you assessed. We're going to assess where you're currently at. We're going to assess you for learning disabilities and see if there's anything that you might need help with. And then, you know, ultimately then, we're going to develop a class schedule for you around everything else you need to do as part of your probation plan. So it's really breaking those outcomes down into smaller goals. And then outcome number 2, what's our second big goal? You know, we want to get you sober. Again, that's very overwhelming. Sobriety is going to be our outcome, but what are the baby steps that we're going to take to make that happen? All right. All right, and it gives us several options for that. Outcome number 4, and again, that's all going to vary based on, you know, what their needs are. Sometimes we have more, sometimes we have less. All right, then lastly, we just get everybody's signature, so everybody's happy, court's happy, and then we can move forward to implementing that plan. Once the plan is put into motion, then we come here to page or part 7, and this is just where our tracking. Again, if there's a change that happens in one of those risk areas or needs areas, we're going to mark the change, and again, this is all computerized now. If that changes their overall rating, and then this allows us to keep track of those big goals. Where are we, you know, every so many days, every month or so, we're going to revisit this and see how we're doing. If it is determined that they're not compliant, we're going to talk about why. And then lastly, the goal, of course, is that they are going to meet those outcomes, successfully finish their probation, and we'll note why we're closing the case. Some of these are positive, of course, some of them are not, and then everybody signs it and everybody's happy. So, all right, so that is what the YLSI is about. It's one of my favorite tools, and it's ultimately very, very effective. All right, so let's take a look at the assignments for this week. Please make sure you read Chapter 5 and the corresponding links. The writing assignment this week is going to have you discuss one of the Supreme Court cases. Feel free to use one of the ones I talked about today. Basically, your writing assignment needs to summarize the lower court case. So what was the original court? So the background of the case. You know, he was arrested for making an obscene phone call. What were the lower court case issues? What was the case about? What did the U.S. Supreme Court case find, or the U.S. Supreme Court find? What was their decision? As well as the dissenters. Now, very few U.S. Supreme Court cases are unanimous, and sometimes the dissenting opinions are going to play a really important role in future cases. So understanding what the dissenters, so the dissenters are people who voted against it, the justices that voted against it. Why? What was their reasoning? Because again, that can influence other cases and can be very, very important. For the discussion forum, we're talking about juvenile interviews. When can police interview juveniles? And then, so explain when, and then who do you think should be present and why should they be present? And so that will be what our discussion forum is about this week. All right, as always, if you have any questions, please don't hesitate to ask. Have a great week.